All right. All right, based on the police report, I will make the finding that on or about November 14th, 2020, in Orting, Washington, defendant Anthony McLean committed the crime of assault fourth degree, not domestic violence, but fourth degree, and I'll make that finding guilt beyond a reasonable doubt. Anything you want to tell me before I proceed to sentencing, sir?
No, that other than I just got out of treatment. I start the union. I go to Hell Week this month. Then just grateful for that. You know, you're giving me another chance, and my life is starting to go onto a better path.
Thank you.
What is it?
It's like
Favors?
yeah. My mom does bridges over at G-Will.
Okay. So are you gonna like get into a different union eventually? No, Masons or
Yeah,
or something else?
I'm doing all the dirty work.
Yeah. Okay. Good.
All right, I have made the finding of guilt to assault fourth degree. I've suspended the 364 days and the $5,000 fine. I've suspended. No costs, no fees at this point. The conditions are no criminal law violations. Is there a requirement of no contact with victim?
No.
I think that was in the SOC.
This is not a, yeah, this is
Not a no contact order and no contact with victim in the order.
Yeah, I don't believe so. And this is not
There was a
DV
condition
case.
of release. I don't see that I'm not sure if we put that in the
You put a no hostile contact.
Okay.
You want me to put that in?
Yeah, I would.
Somebody you know. No.
All right, and unless there's any objection, that's all the conditions.
No objection.
All right. You can have them sign. Who's next?
I guess we can do Paul Douglas. He's been patient. Yeah, we're going to do Zuniga Romero first because
Okay.
that's a quick plea.
There is a warrant in the Zuniga case. I object no questions.
All right.
And this is Gustavo Zuniga Romero, 780-8232-932. For the record, Matt Rose, Night Counsel for Mr. Zuniga Romero. This will be a change of plea. Mr. Zuniga Romero will be pleading guilty to the charge of driving while suspended third degree. He understands that by pleading to any charge, he is by definition waiving a number of important constitutional rights. Specifically, his right to go to trial, the right to a jury trial, the right to have witnesses testify on his behalf, the right to confront and cross-examine witnesses testifying against him, the right to remain silent at trial, the right to appeal the finding of guilt after a trial. He is making those rights knowingly, intelligently, and voluntarily. He is aware this charge carries a statutory maximum sentence of 90 days jail, $1,000 fine. He is aware you do have the discretion to impose anything up to it, and including that maximum sentence, irrespective of any joint recommendations of the parties. Although he's a U.S. citizen, he has had his Padilla rights read to him, and he's prepared to go forward with his plea.
Thank you. And is he still online? Do we see him?
I'm sorry?
Is he still here?
Yeah, he's online.
I don't see him.
His name's online.
Sir, you have to get online, unmute.
Oh, I see him. Mr. Zuniga, can you hear us?
Yes, Your Honor.
Did you hear what your attorney just went through?
Yes, Your Honor.
And you understand you have those very important constitutional rights under number 5.
Yes, Your Honor.
Are there any you'd like to go over at this time?
No.
Number 6, there's a recommendation. It is only a recommendation. I can impose up to maximum penalties. You understand that?
Yes, Your Honor.
Has anyone made any promise or threats to make you sign this form?
No, Your Honor.
And you're doing so freely and voluntarily?
Yes.
And it says under number 11 on 6/27/2017 in Orting, Washington, I drove a motor vehicle while my license was suspended in 3rd degree. Is that a true and correct statement?
Yes, Your Honor.
All right. I'll make a finding the plea of guilty is knowingly, intelligently, and voluntarily made. All right, so based on the finding of guilt, I will do the following sentence for the next 12 months, 90 days in jail, 90 days suspended, $1,000 fine, $750. However, case is closed upon payment as set out below. The fine is $250. The assessments are $225. The criminal conviction fee is $43, and the criminal traffic fee is $102. You can make monthly payments, and if you cannot make a payment, Mr. Zuniga Romero, you need to call the court, and we will arrange another setup for you, okay?
Okay.
All right. Any questions?
No.
All right. You're free to go. Thank you.
All right, thank
Was there an infraction? There was no infraction with this?
I don't believe so.
All right. All right. Thank you. Have a good day.
All right, you too.
I think we can do Mr. Douglas. He's been patiently waiting for a while now.
But you'd want that one back, so. All right. Mr. Douglas. Can you hear us, Mr. Douglas?
Yes, sir.
All right. Did you have a chance to read the petition for deferred prosecution?
Did.
Mr. Douglas?
Yes.
Did you understand
I
it?
can hear you. Yes, I did.
And do you agree with it?
Yes.
All right. And you understand that this means that the criminal act is treated as a disease, and they are trying to treat your disease. And if you comply with that treatment, at the end of all this case will go away and it won't go on your record. Do you understand that?
I do.
And this is the way you wish to proceed?
Yes.
All right. I'm going to go ahead and sign the findings in order, and I will go through it with you. It indicates that you stipulate, agreed, and acknowledge the written police reports and other documents, reports, or evidence filed in this case are admissible in the case this case is revoked. You've indicated you've examined the petition reports, and you've indicated the defendant's agreement to undertake and pay the costs of the prescribed treatment if financially able to do so, and such other conditions as set forth in the order. You're waiving your right to a speedy trial, a trial by jury, to question witnesses, to call witnesses, and to present evidence or defense. You have not previously granted a deferred prosecution for Title 46 violation. Defendant's stipulation, admission, and statements are made knowingly, voluntarily. This court has jurisdiction. I find the defendant qualifies for deferred prosecution pursuant to Chapter 10.05 RCW and has agreed to the same. You shall complete a 2-year treatment program that's filed with the court, and the agency has sent that treatment program and with a commitment to treat. 3 years from the date the court first receives written proof of successful completion of the 2-year treatment program, but no less than 5 years from the date of this order, upon proof the defendant is in compliance with all conditions, the court shall dismiss the offense. The defendant shall follow all conditions of the said treatment program until modified by the court, and shall not change treatment agencies without prior approval of the court. You shall comply with the following requirements: maintain total abstinence from alcohol and non-prescribed drugs, have no criminal law violations and no alcohol-related infractions, do not drive without a valid license and proof of insurance. You need to submit to the alcohol test of the breath or blood upon the reasonable request of a law enforcement officer who has reasonable grounds to believe the defendant was driving or is in actual physical control of a motor vehicle while under the influence of intoxicating liquor or drugs. Submit to a urinalysis or breath analysis upon demand of the treatment agency. You need to pay court costs in the amount of $150. You need to, if it has not been done, attend the DUI victims panel within 60 days.
I've done
You're right,
that.
this is not a DUI. This is a DV.
Okay. I will have him attend the DV victims panel within 60 days.
I did that.
Today.
All right, and if it's done, then I will look and if it's not done, she'll look and see if it's done.
Okay, yeah, there's a bunch of things that he and the alleged victim submitted today.
During the 3 years following completion of the 2-year treatment program, attend a minimum of 2 alcoholism self-help recovery support groups. Proof of such attendance must be filed, let's say quarterly. There's no indication of emergency response, or is there? There isn't a DUI, so it can't be. And there is no issue regarding, I think there's no requirement at this of an ignition interlock.
No.
The court is going to monitor this case for the next 2 years, and the court monitoring cost is $150 for the 2 years. The defendant shall authorize the treatment staff of the defense treatment agency to communicate freely with the court. The treatment agency shall file reports in the first year every month, second year every 3 months. In the event you fail or neglect to carry out or fulfill the terms or the conditions of the treatment agency will immediately in writing report such breach to the court together with the recommendation. The docket charging the defendant with the crime subject to this order shall be removed from the regular court docket files and placed in the court's special deferred prosecution file. Since it's not a Title 46 offense, that's not here. If the defendant fails to undertake and fulfill any terms or conditions of this order, or the prescribed treatment agency or any other conditions set forth by the court upon receiving notice of any failure, neglect, or violation shall hold a hearing to determine whether the defendant should be removed from the deferred prosecution program and proceed to a stipulated trial on said charges. In the event the court revokes the deferred prosecution status, the defendant having already stipulated the accuracy and admissibility of the police report and any other documents, reports, or evidence filed in this case at the time the court accepted the petition for deferred prosecution shall have defendant's guilt or innocence determined by the court solely considering said evidence. If there are any inconsistency between this order and the treatment plan, the terms and conditions as set forth in this order will be controlling. This matter shall be set for review at any time upon the request of the defendant, the city, or the court. Do you understand, sir?
I do.
All right, I have signed that order. I want to tell you that I think that this is a great choice for you. I hope that you succeed, and I hope the only hearings I have with you are for that you're in compliance and doing well. Okay?
It will be the only hearings you see.
All right.
hear from
Thank
me.
you. I wish you well then. Have a good day.
All right. Thank you.
Allison Walker.
Yep. And who's the gentleman here?
He's pro se.
If we could do Miss
Yep. Walker.
Miss Walker first now.
All right. Now we have Miss Walker and Miss Johnson still online.
Yeah, and Your Honor, Ms. Johnson just joined us a little while ago. I don't know if the court wants to continue that. I'd have no objection to.
I think she's been with us quite a while, actually.
Has she? Okay,
Yes.
well, then I will need a breakout room.
All right.
Okay.
All right. What are we doing, Miss Walker?
Okay, Allison Walker, there's actually a companion case, but this is for 9Z115-6716. Ms. Walker will be entering a petition in court for deferred prosecution. She understands that by doing so, essentially what she's doing is acknowledging that she does have an issue with substance issues and that there's a substantial likelihood that she'll reoffend without treatment. She is entering a 2-year treatment and has actually been participating for some time in a 2-year treatment program. She is aware that in order to avail herself of the deferred prosecution, she has to waive a number of important constitutional rights: the right to go to trial, the right to a jury trial, the right to have witnesses testify on her behalf, the right to confront and cross-examine witnesses testify against her, the right to remain silent at trial, the right to a speedy trial. She is making all those waivers knowingly, intelligently, and voluntarily. She further is aware that she's stipulating to the admissibility of the police report, which will be entered into a special deferred prosecution file with the court. If for some reason she falls short and the deferred prosecution is revoked, this will be a pre-admitted exhibit, and essentially yourself or whoever's on the bench at that time will read the police report and in all likelihood find her guilty of the crimes alleged and proceed directly to sentencing. In other words, Ms. Walker knows that as of today, she is irrevocably waiving her right to take these matters to trial. As to the other DWLS 3 charge, which is out of the 7-day statutory time frame, I haven't really resolved that. I don't know what Mr. Walls wants to do with that, but I believe Ms. Walker is relicensed, so I'm hoping there'll be an amendment.
All right. And Miss Walker?
Yes.
Can you hear me?
Yes.
You heard what your attorney just said.
Yes.
All right. So you've reviewed your petition for deferred prosecution, correct?
Yes.
And do you agree with what it says?
Yes.
Is there anything in there that you do not agree with?
No.
All right. And so based on that petition for deferred prosecution, excuse me, I'm going to enter an order. And I'm going to go through the order. Defendant stipulates and agrees, acknowledge the written police reports and any other documents, reports, or evidence filed in this case are admissible against the defendant and are sufficient to support conviction of the offense charged under the cause number if the deferred prosecution is revoked. The defendant has examined the petition and reports. Is that correct?
Yes.
And has indicated defense agreement to undertake and pay the cost of the prescribed treatment. Is that correct?
Yes.
And do such other conditions as set forth in this order. You've
Yes.
waived your right to a speedy trial, a trial by jury, the right to testify, the right to question witnesses, the right to call witnesses, and the right to present evidence. Is that correct?
Yes.
You have not been previously granted a deferred prosecution,
No.
and you're making these stipulations, admissions, and statements knowingly and voluntarily.
Yes.
Okay. I do find that you qualify for deferred prosecution pursuant to 1005 RCW, and you have agreed to the same. So you shall complete the 2-year treatment program filed with the court. 3 years from the date the court first receives written proof of the successful completion, but no less than 5 years from the date of this order, upon proof the defendant is in compliance with all conditions, the court shall dismiss the offense charged under the above cause number. The defendant shall follow all conditions of said treatment program until modified by the court, and shall not change treatment agencies without the prior approval of the court. The defendant shall comply with the following requirements: maintain total abstinence from alcohol and non-prescribed drugs, have no criminal law violations and no alcohol-related infractions, not drive without a valid license and proof of insurance as required by law, submit to an alcohol test of the defendant's breath or blood upon the request of a law enforcement officer who has had reasonable grounds to believe the defendant wasn't driving or was in actual physical control of a motor vehicle while under the influence of intoxicating liquors or drugs, and submit to a urinalysis or breath test upon the demand of the treatment agency or court. You understand those conditions so far?
Yes.
And are directed to pay court costs in the amount of $150. Appear in court anytime requested by the court through the period of this deferred prosecution. Have you completed the victims panel on this?
No, I just read that I have to do that, so I have to set that up.
I'm going to
I think Stop does it.
I'm going to give you 60 days to do that.
Okay.
And during the 3 years following the completion of the 2-year treatment program, you need to do 2 alcoholism self-help recovery support groups per week. Is there an ERC in this one?
There should be.
Sorry. There is. It is 467, or sorry, 463.57.
Objection there.
And there is no additional requirement by the court for ignition interlock.
It's per DOL.
I'm placing you on court monitoring for the period of the treatment, and it's $150 total for that cost.
Okay.
And let me finish this last bit here. There's a lot of this that doesn't apply. You must keep the court advised of any address change. Keep the court informed of any new criminal law violations. They shall authorize the treatment staff of your treatment agency to communicate freely with the court regarding your treatment. The treatment agency shall file reports for the first year every month, for the second year every 3 months. If you fail or neglect to carry out or fulfill any of the terms of the condition or conditions of the treatment program, the treatment agency shall immediately in writing report such breach, Together with its recommendations, the docket charging the defendant with the crimes subject to this order shall be removed from the regular court docket, filed and placed in the court special deferred prosecution file. For Title 46 offenses, an abstract of defendant's acceptance for deferred prosecution shall be sent to the Department of Licensing. If you fail to undertake and fulfill any terms or conditions of this order, or the prescribed treatment agency, or any other conditions set forth by the court, after receiving notice of any such failure, shall hold a hearing to determine whether the defendant should be removed from the deferred prosecution program, and then proceed to a stipulated trial on said charges. In the event the court revokes the deferred prosecution status, defendant having already stipulated the accuracy and admissibility of the police reports and any other documents, reports, or evidence, in this case, at the time the court accepted the petition for deferred prosecution, shall have defendants guilty or innocent determined solely by the court, considering said evidence. Too much talking today. If there are any inconsistencies between this order and the treatment plan, the terms and conditions as set forth in this order shall be controlling. Do you understand all those terms, ma'am?
Yes.
All right. And is this something you want me to sign today?
Yes, please.
All right. So I'm putting this in your hands. I expect good things. I do not want this to come back and have to revoke it. I want you to follow this, and this is your one great chance, and I hope you take advantage of it, ma'am.
I am, for sure. And I'll get that DUI's victim panel in too as soon as possible.
Your Honor, she was also here on an older driving offense third degree. That's 90430-218. And so her licensing situation looks a little complicated. She did reinstate in May, It's currently showing invalid. It appears that that is due to an out-of-state issue.
I paid it.
Okay, so I wanted to let you know that at this point, DOL still has this out-of-state issue that so you'll need to contact them. And I do see that as of today, she has her SR22 was accepted. So everything looks good. City is moving to amend to no license on person.
Okay, so the second criminal case, ma'am, the city is moving to amend this to a no driver's license on person, and which means that that it's just an infraction, and upon paying the infraction, the case is closed. Do you wish to do that?
Yes, please.
All right. So this is under cause number, this is 9Z0430-218. No, it's amended to no driver's license on person. I make the fine $139 upon payment. That case is closed. All right. Anything else from either side? All right. That being no answer, Ms. Walker, you're free to go. Good luck to you. I'm really hoping things work out. Okay.
So I just called the court and set up payment arrangements.
You can set up a payment by calling court. Probably not till about 3 o'clock today.
Okay.
All right.
Perfect.
Any other day you can get them in the morning.
Okay.
All right. Thank you.
Thank you. All right. Bye.
You want to talk to Dennis?
Yeah, did you see my email?
I know.
Yeah, you said you talked to Mr. Hansen?
A couple days ago on the phone. Got out of mid.
I'm going to note the FTA this one time, and we're going to reset for 2 weeks.
Yeah, I don't think he was planning on it.
And you said you haven't heard on Nathan Larson, or have, Mr. Walls? That's on Philip Sue?
Your Honor, I did submit an agreed order amending to nuisance at 175.
All right, so 175. So can you find that order on Nathan Larson? If you can't right now, it's a
we know where that is. Yeah. Well, and then the new. Do we have anything since the new? That's my concern.
Did we already do Jamie Johnston's case?
No, we're working on.
Oh,
we could address.
Well, it's close enough. So on that, it's amended to nuisance in 175.
Yeah. And I can address Mr. Havoc.
All right. Here we go. So that is Mr. Larson.
Yeah, okay.
All right, I'm ready on whoever you're ready on.
Your Honor, if we could address Mr. Havoc, he is here on a driving suspended third degree. He has one ticket left to deal with, and then he needs to take the test. And obviously, he needs some time to get that done. If we could set this over 90 days, I did review his speedy trial rights, and he agreed to set this over.
That's 1/4, is that right?
I believe that.
Is that the first date in January? Mr. Rusnick, you told me earlier, is that the first date in January?
Yes, the 4th, I'm sorry.
Okay,
yes.
thank you. I knew that you said it, so I just asking if you remember. So it's 2022 at 10 a.m. So we went to the whole year basically on this one without changing this to 2021.
There's a new pending.
Just kick it over.
Yeah.
I'd be okay.
Yeah. Let's kick it over.
So, Mr. Havoc, I don't know if the prosecutor explained it. You have a right to a speedy trial within 90 days. And in order for me to grant that continued, you'd have to be willing to waive that right to a speedy trial. Are you willing to do so today? All right. So the new commencement date will be on 1/4. All right, so have him sign that. Thank you, sir. Have a good day.
Thank you. Thank you.
Your Honor, this is Jamie Johnson.
Good afternoon. I think it has changed after that.
Your Honor, at this time, we're just asking for a 2-week continuance. We're still working in the negotiating stage.
All right, this will be an excluded period for speedy trial purposes.
And I don't know if Good Sam's really going to be able to.
You just said 2 weeks, Mr. Resnick.
I'm sorry?
You said 2 weeks.
2 weeks, yes, please. Yeah, I know. Kaiser's really, yeah. Yeah, that's it. Yeah, that's something.
All right, granted, thank you.
Thank you, Your Honor.
You can shut us down.
There are a couple other cases we should address.
All right,
Number 1 on the 845 is an expired warrant.
number 1 on 845. Okay,
At this point, the city is moving to dismiss without
Sign the
prejudice.
date. Okay.
Number 2 on the 845 is also an expired warrant. City moves to dismiss without prejudice.
okay.
Laura Heminger is just an FTA. Donald Warnick is the last one on the 845. It's an expired warrant. City moves to reissue.
All right,
Okay.
move to reissue. Reissue. You know, I typically try to keep these notes on here. And sometimes you guys can actually read this. So anything on the 9:30, I think most of everybody showed except for Hanson, and I reset that for 2 weeks.
I think there's Bonstein
On the 9:30?
on the 9:30. Did that? Oh, wait, that got struck. Okay.
Okay, and let me look at what else I have here. I don't have,
I know we're not the terms, but I have.
well, that's weird. Everybody else appeared on that calendar.
Sure, yeah.
So then we have nobody not appearing until Monago. I don't know if you've heard anything from Monago. No?
No, he's not licensed. And Gil is not.
Then we
Maybe
have
we'll get you into some kind of,
Rebecca Reed.
maybe I can talk to them.
Did I ask?
Oh, Ms. Reed is actually licensed. So the city would move to amend to no val license second degree
Domestic violence evaluation.
and set that over to an infraction
It's
hearing.
an alcohol problem.
So that is 015.
Oh,
There's
15.
two things here going on, some kind of domestic.
All right. So that's,
Each one was
when
considered one
they put
separate.
015, that's this one here.
Whenever.
That's what he's
Take
amending
it out
to.
of domestic, just to say.
And so then that goes on the infraction calendar.
The last part.
Willard Stewart. No, sorry, Benjamin Roberts. No contact order violation. No word from him.
He has worn out it. It's that.
And there's going to be a warrant out of this one. Willard Stewart.
I talked to him a while ago. He was supposed to meet me and retain me. He never showed up. He never returned my calls, so I have no further contact with him.
FTA.
I'm going to stop. I stopped chasing people after a while.
And what are we doing about Mr. Kreibel?
Your Honor, Mr. Kreibel is currently held on felonies with a trial date in November. It does not appear that they are willing to transport him. If we could reset this to the second date in November, check on his status. I get his jury trial scheduled at the end of November. So
All right. And then all I have left is the traffic tickets.
there you go.
You ready to go through them?
Just want this to get added. Like,
All right. Hopefully that clock is,
get added to what I'm.
oh, good, because it was an hour behind before. I was going to say that the traffic calendar should be starting it. All right.